The worst thing is to have nothing. Now, probate, let me step back, is essentially, one of my partners likes to say, it's essentially a lawsuit against yourself. Sometimes it's more important for those that don't have a lot to absolutely make sure it is protected. So it is there for their children if something would happen to them.
It's just better to do it today.
Yeah.
It's better to do it now as opposed to after death or when something happens to you and you can't make the decisions anymore. And it's also better to do it now than once you find out something like a diagnosis and now you're in a mad scramble. So, women, they carry a lot of emotional and financial burdens, or the financial heaviness, I should say, and the caregiving load of family. Usually, it's women, I would say, right? Um, and so, talking about trust and deeds, POAs, those kind of things, what's happening is we're trying to protect our children, we're trying to protect our assets. We're trying to have, we want to do what our loved ones want, right? We're trying to protect our peace of mind, even, right? Um, so with this, Amber, if you could tell me what's your perspective on that? And I know you have like these stories. You were telling us before we started that you have these stories, but what's your perspective on that? If you were talking to someone came into your office and they really didn't know where to start, what would you say to them?
So to the point of women carrying the
The bag.
the yeah the
The bag.
We carry. Yeah.
if it comes to that, yeah.
Mhm,
But
mhm.
I see it a lot. A lot of times it is women that are spearheading the effort to get their ducks in a row as far as to have an estate plan in place. It's not always the woman, but it often is. And the interesting thing there is that a lot of times they come in kind of riled up and sort of stressy and just like, I don't really know what I need to do, but I need to do something,
Right.
and then just having a plan and a path forward, just you can see they're relieved and that they're on their way to having their peace of mind back. To uh, so many people are like, this has been on my list for years, and we just kept pushing it off and blah blah blah, and they're just relieved when they finally do get something in place.
Mm. So many people don't realize that they're missing this one document. What would that document be? You'll probably say it's not one, but so many so many
I can
people
remind
don't
you here
realize that
because
they're missing this one document and it could cost their family everything. What would that one document be? Or maybe many.
yeah, it depends on the scenario. It really depends on the
Mhm.
scenario. I've seen people who think they have a trust plan in place, and so I'll tell a
Let's
story.
talk about that.
Yeah,
Yeah.
let's talk about it. So I've had a client come in, and he was really frustrated, very, very frustrated. He was the trustee of his mom's trust. And the problem was, and we can get into this more later because it's like one of the huge important things about having an estate plan, and particularly more specifically a trust based plan, is the funding of the trust,
Mhm.
meaning the accounts, everything is directed towards the trust so that the assets are in the trust and not
Mhm.
outside of. But in this particular instance, he was the trustee, but his mom, and I'm assuming that counsel wasn't very good because nothing was funded to the trust. So it was this empty trust. There was nothing in it. And talk about a document that was missing, a pour over will. When that is kind of a catch-all. If you have a trust, you also need to have a pour over will for
Okay.
something that if something isn't aligned to the trust, if it's not in the trust per se, and it falls outside of the trust,
Uh-huh.
that document has to go through probate still. And, or excuse me, that asset has
Has
to
to
go
go
through
through
probate.
probate.
Now, since nothing was funded, everything should have gone through probate, but there was no pour over will. So they were in the middle of this intestate probate, which means you dying with no estate plan. So
Mhm.
whatever this woman paid for this estate plan, it was missing that crucial document. It was missing the follow through because nothing was funded to it. But if there was a pour over will, at least it would have, the design of the trust would have held up after you went through probate with the pour over will. So it got dumped into the trust.
Mm.
So the trust literally had no function. Um, and they were going through the worst type of probate
Oh my
because there was
goodness.
no pour over will. So when you say one document missing, that's definitely one circumstance that just like
Oh my
screams
gosh.
that.
Wow.
Hmm. So it's almost like we need to kind of back up a little bit because just looking at some of the statistics around wills and trusts that I was just looking at a statistic that said uh, 13% of people actually have a trust and 24% say that they have a will. And this was taken in 2025. What is the major difference when we're talking about wills and trusts? What's the
And
difference?
estate planning.
Yeah.
So trusts and wills are all vehicles or tools within estate planning. We'll just say that to begin with.
Mhm.
Um, Another important point is that there are tons of different types of trusts,
Mhm.
but the most common one that people are thinking about is what's called a revocable living trust.
Okay.
That's something that is completely revocable, amendable, changeable, whatnot, until the death of the grantors. Um, the second, so if it's a married couple, planning together, and they have a revocable living trust, it's completely changeable, revocable until the surviving spouse dies.
Okay.
So,
Mhm.
Mhm.
so let me just say that. And when people say I have a trust, that's unless you're talking about really advanced estate planning
Mhm.
techniques, that it's typically the revocable living trust that they're talking about. And like I said, if you have that, you should have a will. Also, you should have what's called a pour over will, like
Mhm.
pouring liquid.
Yes.
Mhm.
Um, but also, I think I'm not sure exactly how accurate the statistics are because a lot of people don't know the difference between a will and a trust. And they might
Mhm.
say they have a trust and maybe they have a will, but
Mhm.
maybe it has testamentary trust verbiage in it, which
Mhm.
means that after it goes through probate, it creates a trust, but that doesn't mean it's a trust right now. So
Mhm.
that's really kind of interesting. But um, from a high level, uh, let me step back. The worst thing is to have nothing.
Mhm.
So
Okay.
if you have even a will that you downloaded from the internet 20 years ago, if the
Mhm.
internet was around 20 years ago, it's about, then that would be better than nothing. I
Hmm.
mean, potentially better than nothing. But
Hmm.
So, okay, because based on your question, because I came to y'all originally um wanting just a will. We wanted to just make sure the will. We were oblivious of all this other stuff. So, like you were asking the difference between the will and the trust. That's when you guys began to tell me about the difference. Like you gave me this education. So glad. So if you have it, you said at least have a will. But if I just have a will
it still
and
has
not
to
the
go through
trust and all this
probate.
kind of stuff, if something happens, then what happens? If something happens to
Typically,
me
you have to go through probate. I mean, not
anyway, still a
yeah.
will is not
Oh
going to
yeah.
keep you from that.
No, no, a will, all that it, well, not all that it does, but basically what it does is it puts your wishes for after probate, how you want things distributed. So
Mhm.
if you are intestate, you end up dying intestate, meaning no will, no estate plan at all, then your wishes aren't documented. But that's not to say, but the state of Texas will tell you how it's going to go.
So no
They're saying
will, no anything. If you go, you pass the state of Texas, and it depends on the state you're in. I know we
mhm.
have many states watching, but in the state of Texas, what happens? They go.
there's set laws and a path of distribution of assets, generally speaking. So it would start with, like, if I died, it would start with, then my spouse gets certain portions depending on community property and type of property, and then my children. And if I didn't have any children, then it goes to, like, your parent level. If they're not around, it goes to your sibling level. If you have three siblings and one of them is gone, then um, the third that would have gone to that sibling goes to their kids. Like, there's this whole structure of what would happen to your property if you die without a will, and that means it may or may not be your wishes.
And
May
that's a
not be
simple case, right? That's
yeah.
that's just a simple case. With my family, we are a blended family.
Hmm.
So now it's not just Kaya and Joshua, it's all of my babies, all of our even our my bonus babies that are
Mhm.
involved, and that can affect some things. And
Oh yeah,
so,
it
yeah.
can get very, very complex and complicated when you have blended families.
Mm.
No,
So
what's a living will?
okay, that's actually an advanced healthcare directive.
Okay.
That's the situation. It's a legal document, but it controls the situation that if you have a terminal irreversible condition and you're on life support, do you want to stay on life support or pull the plug? That
Mm.
is what's called a living will. Is that the document that controls that scenario?
Oh,
Mhm.
okay, so you're talking
So,
about the will. So if you have
mhm.
your will, yeah, but then you're saying there's
But
some other
wills
things.
typically have to go through probate. Some very simple scenarios, if you have a parent that dies and you're a joint owner on all of their accounts, you live in the home with them, it's
Mhm.
the home is, if it was in your name, if there's nothing to needed to get title out of somebody's
Mhm,
name,
mhm,
that's you could avoid probate.
mhm,
Now, probate, let me step back, is essentially, one of my partners likes to say, it's essentially a lawsuit against yourself. And it
mm,
is, because your estate is paying for it.
mhm,
And what it does is it starts a statutory period of time of notice to everybody that you passed away. And then in Texas is 120 days
Mhm.
that the estate needs, that period of time when people can make claims against your estate. So you
mm.
have to, like, go through the whole process of, like, publishing the notice, and then creditors can make claims against, and during which time fraud can happen and all this. And it's a
Mhm.
public proceeding too. Your wills are like public,
What?
are public
Knowledge. Wow.
knowledge. Yeah, you might have to
Mhm.
pay a filing fee or something to see it,
Wow.
but they are out there, and
What?
so everybody can see how you want things to be distributed. It's a very public situation. Trusts are not; they are
Mhm.
private.
So that's why you need a
But
trust.
that's one of the
A will and
benefits
a
of it.
trust.
Okay.
That's one of the benefits of having a
Mhm,
trust, is that you can avoid probate. But
mhm,
with the will, um, so let me back up. There are scenarios where somebody can have a will based plan and they can avoid probate,
mhm,
but that's few and far between.
Mhm.
You would have to have, make sure all your beneficiary, like pay on death beneficiary designations, are as you want them on your accounts. And if you can have certain kind of deeds on your home that upon your death it immediately transfers to someone else, and that type of thing. But the whole purpose of creating a will is with the understanding that it has to go through probate.
mm,
Um, but in talk about probate in Texas, Texas is what they call a probate friendly state, and that's because essentially the statutory period of time for the estate to be open for to make claims against is 120 days.
Mhm.
Other states are a lot longer. I
mm.
can tell you, South Carolina is like 8 months.
Oh,
Oh,
So
wow.
120 days is what, 4 months? So it's
right.
twice as long. I have a story about that. Um, my aunt died a little over a year ago. I think it was a year in March. So her and my uncle owned a home in South Carolina. So my uncle, in the middle of, grieving and
Mhm.
everything, but he started the probate process to get my aunt's name off the home so that he could sell it or
Mm.
whatnot. Well, it's like I said, it's an 8 month long process there. He dies 6 months later,
Mm.
something around there. And then my cousins, so when I went to his funeral, I have 3 cousins who don't live in the state, who had a really crappy year, right? Because they lost both of their parents. They still had to wait 2 months or so until the probate for my aunt was
Oh,
finished and the
wow.
house was in my uncle's name. And then they had to start the proceeding for
All over
him
again.
Another
all over
thing.
again.
Wow.
So
Wow.
they can't sell the home. They can't but more importantly, in my perspective, they can't move on.
Right.
They're
Right.
just stuck.
Stagnant. Yeah.
So they're paying a mortgage or paying the upkeep on this property that just sits there for how long?
Mhm.
Just now it's been I guess, over a year since it was in March. So just now they're able to like put the house on the market.
Mm.
And meanwhile,
Yeah.
just they couldn't move on.
Wow.
So
Okay. So the
it's
one of the things you said first is have something, because many
yes.
people don't have anything.
Yes. Hmm.
But if you do have a will, understand that it has to go through probate,
Hmm.
which can be, depending upon your state, a lengthy amount of time.
Lengthy amount of time
Okay.
and expense. Like in Texas, I mean, on average, for a very simple probate, it's about $5,000
Mm.
Mm.
and stress.
Hmm.
And a lot of people that that again
Can
can't. They're
see.
in the middle of grieving and
Right.
they can't move on. So
Mm.
And then the trust, one of the other things that a trust does is protect you from that time period, or
a trust. So it's not technically a separate legal entity in Texas. You don't have to register it with the Secretary of State or pay
Mhm.
separate taxes on it or
Mhm.
anything like that. But if you think of it like
Another
a
person,
legal entity, if you think
another
of it
legal
like that,
entity. Okay.
it's helpful. So
Okay.
not necessarily a person, and I'll tell you
Mhm.
why, but
Okay.
more of like a legal entity.
Okay.
Because there's like 3 parties with a trust. There's the grantors, there's the trustees, and there's the beneficiaries.
Okay.
Okay. When you create a trust, you're all 3 parts. You're all 3 parties. You're the
Mhm.
grantors, it's your assets. You're managing it as trustee for your own benefits. So you're all 3 parties.
Okay.
And you can change it, you can move things in and out of the trust, blah, blah, blah. And but like then the home you move in to the name of the trust.
Mhm.
And now like on the deed, it will say um, Andrea, trustee, or her successors in interest
Mhm.
of the Wormley Family Trust, dated
Mhm.
blah, blah, blah.
Mhm.
And so when Andrea passes away, her successor in interest, the next trustee immediately has access to it because it's not her as an individual named on it. And that's how it works. Like a
Mm.
trust, if it's a legal entity, it doesn't die, right? It
Mhm.
doesn't.
Mm.
So there's nobody's name to get off title ever.
Mhm.
And so you skip any need to go through probate and transfer title. Does
Mm.
that make sense?
Yeah.
So
So,
you can put everything under the trust:
mhm,
vehicles,
yeah. You
personal
assign all your tangible
possessions.
personal property
Okay.
to the trust. The home, any real property, any
Mhm.
mineral rights, and it's
Any
all owned by the
businesses,
trust. Yeah.
any land,
Yeah,
any
businesses.
Yeah.
Okay.
investment properties. Yeah.
You would link like a business or your interest in the business through the operating agreement of the business. You would link that to your trust.
Wow.
Mm.
Yeah.
Wow.
Um, so you skip the need whatsoever of having to get a person's name off of a title for anything.
Mhm.
And there's no notice to anybody that anybody died or anything like that. And
Mhm.
another one of the best things, it's all private. There's nothing that gets published on it. Like the trust itself is private. The only thing bank accounts need to see, or banks or financial institutions at all need to see, is what's called a certification of trust, which is a page and a half or 2-page document, which just has the main important things about the trust, the name of the trust, the names of the initial trustees, the names of the successor trustees, and that's it.
Mm.
I mean,
Mm.
some other little information, but for the most part, that's the only thing that anyone needs to see. So how it's distributed, how everything else is all private.
And you said that you avoid probate if you have the trust.
Hmm. Yeah,
Yeah.
if it's funded, if
If
it's
Yes.
funded properly.
if it's
Yeah.
Can we talk about the funding the trust? So,
Sure, yeah.
okay, so
Yeah.
what does that look like? Explain that to
So
us.
like cash accounts, checkings and savings accounts, money market accounts, that type of a thing,
Mhm.
they are just retitled in the name of the trust. So now you're accessing them as trustee of the trust. And then when you're gone, whoever's the successor trustee, they have access to it by virtue of being the trustee. So in that way, all of those accounts are always so they're aligned is the word that we like to use. Either you
Mhm.
retitle it in the name of the trust or um, certain accounts, and it depends on the institution how what their preference is. Because again, it goes back to like what is their policy, what is their whatever.
Mhm.
They sometimes don't like to allow retitling in the name of the trust. So what it would be is you designate the trust as the pay on death beneficiary.
Mhm.
Mhm.
So in that way, it's lined, and because it's a lined, excuse me, because pay on death beneficiary that goes outside of a will or outside of a trust, that would go first. And so if the
Wow.
pay on death beneficiary goes to the trust, then it's aligned in that way.
Mm.
What if the way you want to set it up is the person that gets it is too young at the time? What do you do in
That's
that
another
situation?
wonderful thing with the
Mhm.
trust is you get to you design it however you want.
Mm.
It's really super fun that
Mhm.
it's not like things have to go outright.
Mhm.
Um, you can't legally inherit if you're under 18. And then even if you are 18 as a parent, do you want your kid to get a big lump sum of money at age
Mhm.
18? I don't think
Mhm.
that's very healthy.
Mm-mm.
That's
Yeah.
in a lot of scenarios,
Mhm.
maybe some super mature people could handle it, but
Mhm.
Yeah.
you can design it however you want. I can tell you personally, I'll tell you how I have my trust. So we have 4 kids. So their ages are 13, 15, 16, 18. So,
Wow.
Mhm.
they're not tiny, but they're not of age, all of them
Mhm.
certainly. So the way that we designed ours is we have something called a common trust, where any funds, if something happened to my husband and I, it all stays in one big pot, basically, and it's used for the benefit of all of the kids. In generally speaking, there's no primary beneficiary, or just it can be used in an equitable but not equal way. So it's
Mhm.
kind of how we parent
Mhm.
our
Mhm.
kids in general. If one kid needs braces, I'm not like, okay, that's $8,000. What's $8,000 that this kid needs and this one and this one? No, it's just like you do what they need and what's fair, and it's not
Right.
all
Mhm.
completely equal, but it's equitable. So then when my youngest reaches 18, what I have is that it separates into 4 separate trusts,
Mm.
and it stays in trust. Um, and it can be used by the trustee for the respective beneficiaries' health, education, maintenance, and support. So that could include, college and things like that. But they don't have a right to withdraw any of it. They have a right to withdraw from their separate trust 25% when they reach 25, 25% at 30,
Mhm.
25% at 35, and 40.
Mhm.
That's how I have it now because I don't know how responsible they're going to be
Right.
and
Mhm.
what their
40.
path looks
40
like.
years old.
So and honestly, it's not going to be a ton of money, and they need to be focused on their own
Right.
lives, figuring out how to support themselves,
Right.
do all this, not
Mhm.
getting
What they're
some
getting.
amount of money from me and
Mhm.
from my husband and I, but those funds can stay invested and grow, and maybe they'll have it'll be there for it can always be used for the health, education, maintenance, and support. It's just their ability to pull out or withdraw some of it that's different. But anyways, that's how I have mine. Other people have like it could be totally different.
Mhm.
Yeah.
That's good.
Ours is kind of different. Did you have a question?
Well, mine was about, it is still about the children. So if a parent has not established um, a guardian in the will, how does the state look at who raises the children?
That's good.
Well, that's it depends on the situation of what happens to what happened to the parents, where they were at the time,
Or
if something
parent.
parent yeah, if
Yeah,
something
yeah.
happened to, um, a single parent or the both of them, and
Mhm.
there it was a car accident or something, and there's no family nearby, then that's when foster care comes in it.
Oh my
Like,
gosh.
Mm.
so not ideal. The that but that's how that would go. Um, but it wouldn't necessarily fall to a family member either. So it just depends. That's the scary part. It's
Yeah.
like, I don't know. Let's
So
wait
if
and see what
if
happens.
if you died tonight and you didn't have anything in place, who would raise your kids? That part.
Yeah,
And you're
so
saying foster care.
it really depends
Good.
on where they are at the time. Is there a family member that could step in and then go try to get guardianship of them? And if it's a safe scenario, then potentially the kids could stay with that person, but they'd have to go through the legal proceeding to
Mhm.
get to be declared the guardian.
Meanwhile.
And that still puts them into possibly a foster care situation.
Possibly. It really
Possibly.
depends on the jurisdiction. It depends on so many different things.
Yeah,
I
yeah.
mean, my husband and sons, they're like, "Can't you just give us an answer on so many things?" And I was like, "Yeah, the answer is it
It
depends."
depends.
Like
Mhm.
it's because it's very, very fact specific.
But you can create something
Yeah,
to
actually,
protect
Now,
that.
yeah.
yeah.
Nomination of yeah, guardian, short-term guardians and longer term guardians for your children. Certainly. Yeah, you can put that in place, and that gives you a huge say in what happens when you're gone.
And you
So
can designate that in the
You can
will, and then
designate.
that is immediately followed.
Not no, they
Mhm.
still, so if it says that, they would still have to go through the legal proceeding in court to be declared the guardian. But
Mhm.
if you have it in writing who you want it to be, that is very strong.
right.
Um, I wouldn't necessarily say always followed by the
Mhm.
judge, but it gives you a huge say in what happens and what you
Mhm.
believe is in their best interest.
So tell us about Amber, just who you are, what you represent, all those kind of things. Tell our listeners all about that.
What's your story?
What's my
Yeah.
story? Oh gosh. Well, I'm an attorney. I've been an attorney over going on 16 years. I started my practice in the intellectual property area. I'm actually a registered patent attorney. My
We will be
undergrad.
talking about that in the next episode, by the way.
There you go. Yeah, my undergrad was chemical engineering. I did more of the science based and then decided to go to law school. Um, but so that's where I started my practice. And then after being in some different firms, I started my own firm and branched into more, like, I do a lot of other IP as well, trademarks, and I worked for a number of years with a legal services firm. I had my own IP clients, and then I did different merger and acquisition projects, some big M&A projects. It
Hmm.
was really fun. So focused on kind of just some general, a lot of different contract negotiations, buy sell agreements, a lot of business formation, all that. I worked with a number of startups, which was really exciting and kind of fun. But about 5 years ago, I started incorporating estate planning into my practice, and to be honest, that's the majority of what I do now. I still have a lot of IP and business clients, but um, it's really super fun how you can link your business interests with
Hmm.
your family estate plan, and that's
Mhm.
actually a really important aspect of things that a lot of people don't know about or don't think about. And um anyway, so that's kind of me professionally. On a personal note, I'm married to a fantastic man and we have 4 kids. So
Awesome.
yeah,
Wow.
Mm.
Wow. Okay. And you're in your practices here in San Antonio.
it's in New
I mean,
Braunfels,
New Braunfels.
actually.
Sorry,
Yeah.
New Braunfels. Okay. Alrighty. So I know you had a question.
I have a few, but I'll start with this. So, if our listeners they're watching this podcast and maybe they have nothing in place, um, and a lot of times people procrastinate and they think I have time to do this. We'll
Mhm.
get to it. And other times it's about cost. They don't feel like they have either the assets to do a trust or a will, or maybe they just feel I don't have the funding. What is your recommendation? I know I just said a bunch of scenarios, but
Yeah.
what is your recommendation?
I think it's super important, and it's very true. It's definitely something that people push off and push off for a long time. No matter how sophisticated or, business oriented or educated people are, it's often something that gets pushed off. And many times people are going through probate for a parent, or saw a friend or
Mhm,
someone go through a really messy probate situation, and they realize, okay, this this is
mhm,
we got to get something in order. So that's one scenario I see a lot. People come in with elderly parents, and they're like, oh, and we don't have anything in place, that type of thing.
mhm,
um, Another scenario is they got some scary diagnoses. That's
Mhm.
that's
mhm,
um very common as well.
Mhm.
mhm,
And they all of a sudden they see the end coming,
mhm,
and it's time to really make prioritize
mhm.
estate planning and make sure things are taken care of for their children as they wish. Um the A lot, like, another point that you said was that a lot of people, and it's very true, I hear, well, I just have my situation is really simple.
Yeah.
It's like the it's simple, it's straightforward,
Mm,
this and that. And or I don't have very much. I don't have very many assets. So, like, I just need a will. I don't need a trust,
Yeah.
that type of thing. Um Sometimes it's more important for those that don't have a lot to absolutely make sure it is protected, so it is there for their children if something would happen to them. um because you just never know.
mhm.
So
Yeah.
it's very fact specific. Everybody's scenario is very different, but it is laughable almost how often people are like, oh, it's real simple, I just have this and this, and
And
then you talk for a minute, and
and then
yeah,
there's
it's
this
not
cavern
it's
of,
not all that
oh,
simple.
wait.
Like, if you
Right.
want certain things,
Yeah,
um
Protected.
yeah.
yeah, to protect it, exactly. And like you pointed out, the blended family scenario is so common. Even if
Mhm,
it's not a blended family scenario, it can get messy quick.
Mhm.
mhm,
And not only are you protecting assets for your kids, but even kind of protecting the relationship between your kids, because
yes.
when you mix
That's good.
grief and
Mhm,
finances,
Oh my God.
mhm.
that's like
Hello.
atomic level.
Absolutely.
Emotion.
Right.
Yeah,
The emotion.
Yes,
Yeah.
yes.
So I have a question. Can a single person have a will and a trustee?
absolutely. Yeah, we have I have many clients that, well, first off, they should
Right.
have a trust or a will at least. But a lot of people have plan individually. They have their own trust, and then they get married, but they still have portions of their estate that are controlled by their trust that they've already set up.
Mhm,
And one of the key things is to have the type of estate plan that can grow with you.
Mm.
That with a living trust, you can always constantly align things to it as you go along. You can change the designations of who successor trustees are, all this kind of stuff. It doesn't, you can operate just like normal. So,
mhm,
like, if you buy a home, you just don't buy it in your own name. You buy it in the name of the
Right.
trust. You can
mhm,
sell property, move it, like, it's
Right.
such a cool vehicle to a protection for you, that it just is great. But yes, for sure, individual people all the time, single people have uh trusts and an estate plan.
So if I have a will, I have a trust, um, do I need to update it often, or it's been signed and we're good to go? And 20 years later, we're still good to go? Or do we need to update it quite often?
I recommend that at least every
We
so
had that
it
conversation.
depends,
We had that
yeah.
conversation.
At least every 3 years, I recommend that you think about it closely. I'm not saying anything necessarily needs to be updated, but with how you have things organized, like I shared how I have things in trust for my children. Well, down the road, they may be older than those ages, or there may be situations that where I don't feel like I need to keep things in trust for that long because they've turned out really well and they're responsible and whatnot. Um, or that certain people that I've designated as successor trustees or agents in some kind of situation or not. Maybe they've passed away or they're just not the ideal pick anymore. Maybe I have a relationship with a sibling that is not nearly as close as it used to be, and so you don't really want that person to be
Wow.
in that position. So I I recommend you think about it. At least look through it and see if it still meets, it still does what you want it to do. And as like I said, a with trust and aligning all the assets to the trust, there may be like maybe you got some new bank account and you forgot to put
Mhm.
it in the name of the trust. So just like constantly reevaluating if it's still going to do for you what you want.
Mm.
Is it still going to?
What is POAs? What does that have to do
Okay.
with anything? Power of attorneys and the different types. I know there's
Medical,
medical and there's financial,
financial.
and
hmm
what is that? And how is that connected?
So, powers of attorney are only effective while you're alive. What it does is it essentially allows another person to stand in your shoes and make decisions as if they were you. So, if you're dead, they're not making any decisions. It a lot of people
That's
um
good to know.
yeah, a lot
I
of
think
people
you think
think
about
of
that.
powers of attorney as, well, after I'm gone, my power of attorney can do this. Well, that's not true. Like they're ineffective once somebody passes away. But
Mhm.
there is a statutory durable power of attorney, and that's for legal and finance purposes. Um, they can be really general. There's all these different powers you can give an agent under a power of attorney. You can give them control over like real estate, real property transactions, or financing situations, stock trades. I mean, just like all the things, insurance matters, retirement, like all these different powers that you can give them. Um, Sometimes you have limited powers of attorney because maybe you're traveling for work and your husband's closing on a new house. And so you want to give him the power of attorney to act for you in the purchase of or sale of that one property. So sometimes you can have like limited
Mhm.
um, powers of attorney, but the recommendation is to you can have a limited one in for certain circumstances, but to have a general power of attorney, especially as people are getting older, that if something happens to you, so if you get incapacitated, someone needs to have the power over your accounts to be able to maybe pay for your treatment or pay for,
Mm.
that type of thing. Um, but so that's just like the legal finance power of attorney. There's the medical power of attorney. So that's for someone to make decisions over your person or your body. That's what a medical power of attorney is for.
Mm.
But again, if you got hit by a truck and so you have these severe medical injuries, you need a medical power of attorney for someone to tell the doctor, yes, do this surgery or no, do this one, that. But you
Mhm.
also need a financial power of attorney so that they have access to
The money.
the money to be able to pay for your care or to be able to support your kids and like to be able to pay for that type of thing. So even though it's a medical situation that maybe caused your incapacity, you need to have both, right? You need a medical and a statutory durable power of attorney.
Mm.
Wow.
So a comprehensive estate plan, if you had a trust-based plan, it would be the revocable living trust, a pour over will, which basically
Mhm.
says dump it in the trust. And then you have statutory durable power of attorney for legal finance purposes. You have a medical power of attorney to over your person or your body. Um,
And
there's
durable, I mean, not durables. What are they called? Not what are they called?
directives, like advanced
directives.
health.
Sorry, I don't know why because you said the durable, but
Yeah.
directives, and that's a
So
part of.
advanced healthcare directive is basically a statement or declaration by you saying, if I have a terminal irreversible condition and I'm on life support, do you want to stay on life support or do you want to pull the plug? It's essentially
Right.
the pull the plug
Yeah.
situation. That's another important legal document. There's something else called Declaration of Guardian and that's guardian not for children, but for yourself.
Mhm.
And that can be a really important document to have in place too. So like for somebody that has dementia, maybe, and sometimes a doctor's office might say someone is making so many decisions for this other person that it really exceeds the scope of a medical power of attorney,
Mm.
that it's more of a guardianship issue.
Mm.
So if somebody said that, then they might say, okay, so you need to go and get declared guardian over your mom. Well, this is a document you saying, if in the future someone says I need a guardian, this is who I want it to be.
Mhm.
That's good.
Yeah. So whether or not that's good enough for the doctor's office, if they see, say, okay, we want you to go, we feel like you need to go get declared guardian, but you have a declaration of guardian from that person that says this is who I want it to be. And if it's the same person as the medical power of attorney, then a lot of them, because it's CYA for the
Mhm.
doctor's offices, they're just concerned about liability.
Mhm.
But if having that combination, they might just be like, okay, never mind. Like, I feel comfortable with this to allow you to continue making decisions. Because if you went to court with this document from your mom saying, I want you to be declared my guardian, then the judge most likely would be like, okay.
Mhm.
So, anyways, a lot of it is just about in that respect, in that scenario, is about the doctor's offices, needing to protect their liability. But
So we see a lot when you're online and different advertisements for LegalZoom and trustinwills.com and all these different online entities. What are your thoughts on some of these entities online if you're trying to set up a will trust? Are they legitimate?
um, it's not necessarily that they're not legitimate. They might not really truly, a lot of them are forms that you fill in, right? Per my
Mhm.
understanding. And they don't necessarily cover all your bases. They might not be updated to include the current legal verbiage that's
Mhm.
recommended, but they also might not. I've seen a lot of those type of documents that clients bring in. Oh, I just did this from LegalZoom, and it might say, I want, my if my husband dies, then if I die first, my husband's alive, I want everything to go to him. If not, go to our kids. Well, what happens if one or more of your kids are gone? Because it
Mhm.
doesn't. They're not very across the board from what I've seen. They're not very good about having contingent situations. Well, if this happens, then I want it to go to their children in this way or this. All
Mm.
of that. Um, uh, there's a lot of holes in them. Is my
Mhm.
point.
Mhm.
And so maybe it would cover you, but maybe not. So,
And I know a lot of times people will go that route just because of the cost, right?
yeah.
Uh, can we talk pricing on what would it take or what would it look like for someone to receive your services for estate planning? And is it just it depends on what the assets and things that they have and
It does depend. The trust plans in general are a lot more work up
Mhm.
Mhm.
front. So they're a lot pricier than maybe a will-based plan. But if you think about it, that they're avoiding probate on the back end
Mhm.
from, potentially, well, that person, but if they're in a married situation, it could be both. Um, and it's difficult to, I mean, a lot of people are cost conscious when they come in,
Mhm.
which is very smart. That's how I am,
Yeah.
going to different, certainly that, but the important thing to me is make sure you're comparing apples to apples.
Right.
So a lot of people will be like, oh, well, my mom got, or my friend, whatever, got
For
this will
$100.
plan exactly for
Mhm.
$100 or whatever. And, why is yours that much better or whatever? I'm like, well, $100, how long ago? And
Mhm.
what's you pay for what you get.
Right.
You
Absolutely.
pay for what you
Absolutely.
And it's cheaper on the front end than it could be on the
Oh
back
yeah,
end.
for sure.
Mhm.
Yeah. Yeah.
But
You know?
I but knowledge also gives value. I know for my husband and I, once we understood the benefit and the value of it all, we thought that it was going to be crazy amount of
Mhm.
money. But when we found out how much it was like, okay,
Where's that checkbook?
we can do this.
Yeah.
We can do
Now.
this, let's do this
Yeah.
now, before we change our mind. Yeah, right. We can do
Right.
this now. But I would say that it, when you find out the value of it, though, then it causes it to be it's really priceless, honestly. It's not, yeah.
It is. And but again, like one of the things that we are talking about is this trust that one client came in where he was the trustee for his mom,
Mhm.
and it was completely not funded. There was no pour over will. So who knows how much they paid for that,
Mhm.
but they got was a nightmare and a hassle on that the children are doing, and they got no
Hate
value
that.
out of it. That person who did it, or the his mom who had died but paid
Mm.
for it.
Right.
So if you not only is it the legal documents itself, but it is the education and understanding like what is really going to be best for you. So I
Mhm.
even had a client come in earlier this week, and he's like, I have a will, but I feel like I need a trust. My daughter said I need to come get a trust.
Mhm.
So I spent probably an hour and a half with him talking about different things, looking over his documents, all this, and I'm like, honestly, you don't need a trust
Mm.
because he didn't have what he had. All of his accounts were already um he only had the one daughter. All of his accounts, she was either a joint on him, or if or pan death beneficiary. The
Mm.
only thing he needed that he didn't already have was to get a ladybird deed in place, which is
Mm.
a type of a transfer on death deed
Mm.
where it basically you're giving yourself a life estate in the house, and then upon your death the property immediately transfers to someone else, thus avoiding probate.
Lady
Mm.
So
Bird deed.
I'm gonna
lady
write
bird
that
deed.
down.
Yeah.
Ah, wow.
There's not all states recognize them, but certainly Texas does, so that's
Yeah.
Mm.
good. Yeah.
I love the fact that you said, just to her question also, is that when you come in and you talk to an attorney, that person can find out all the different intimate places and caverns and this, that, and the other, and tell you you also need this, and give you the wisdom of it, and also say, but you don't need that. You
Mhm.
know,
Well, that's what a good attorney will
Yeah.
do,
Mhm. Yes.
The
not trying
experience.
to upsell you into something that really isn't going to protect you. Um, so I think that's important
Mm.
for sure.
Absolutely.
But
Yeah.
Yeah, I just had a very basic question. What happens to those things that are not covered, like family heirlooms or um, digital accounts, social media accounts for the loved one that has passed? How are those things
well,
handled?
certain for a will or a trust plan through our firm, um, and I'm with Davideck Law Firm in New Braunfels. They
Say that one more time.
we Davideck,
Davidac. Okay.
yeah, we're rebranding to Texas
Mhm.
Asset Protection Law,
oh, okay.
Mm.
but you know, I think my cards say both right now. So, and it's a fantastic firm. It's really great. The Beverly Davideck and is the owner,
Mm.
founder of the firm, and then Robert Harrison is a partner too, and he's fantastic, really great. Um, but anyways, so I'm going to tell you like the will and trust plans that I see, because I've seen a lot of other ones that maybe don't handle that stuff. You know what I'm saying?
Mhm.
But like a good will or trust, with a trust, you sign what's called an assignment of personal property, where you assign all tangible personal property to the trust.
Mhm.
So we're talking jewelry, furniture,
Mhm.
kitchen supplies, like literally everything, vehicles, RVs, motorcycles,
Wow.
Mm.
um, all of the tangible stuff. You assign it to the trust, so it's owned by the trust. So then the trustee has the authority to go and get rid of it or
Okay.
sell it or whatever. But there's another document that's incorporated by reference into either the will or the trust, depending on which one is the document that has the distribution
Mhm.
set forth in it. And it's a personal property memorandum. And that's where you say, my mother's ring to Addison, or, whatever.
Mm.
But you set forth any specific wishes you have for certain items.
Mm.
So I
Okay.
always recommend that people try to do that while they're still alive,
Yeah.
because
Yeah.
then they can see the joy
Yeah.
they bring someone else. But
Mhm.
since you don't know when you're going to go, anyway, that's how that type of distribution would be handled for heirlooms and
Mhm.
things like that.
Mhm.
There's also verbiage that gives the trustee or the executor, depending on the situation, the power to control digital assets and things like that. Would you say social media?
Mhm. Yeah.
Um, that's kind of a different thing. It's not necessarily an asset, but that brings in all kinds of other things, like all these other accounts that do you want someone to go in it and make a notice so that people
Or
know
close
something
them
happened to
down.
you, close it
Right.
down? Yeah,
Mhm.
Yeah.
that type of thing.
Yeah.
I mean, I presume it would just, for like a Facebook account or something, maybe it would just eventually go abandoned. I don't know exactly
They
how
go
that would
there's a
work.
lot that just go abandoned, I'm sure.
Yeah.
Mhm.
Mhm.
We probably have maybe about 2 or 3 more minutes. Any other questions?
Yeah, one last question I would say, what would you tell our listeners right now that would be, out of everything we talked about, two important things that they need to do today, if they could, as it relates to estate planning, wills, trust?
Talk to their significant other if they have one. If not, then
Mhm.
just for themselves, put something in place, because a will is way better than nothing, because then
Mhm.
at least things will be distributed as per your wishes instead of according to the laws of the state of Texas then in effect.
Mhm.
And maybe, and so for a will, but the other things like medical power of attorney, those type of documents, and make sure that your loved ones know what your wishes are.
Mhm.
Mhm.
Because even if they're designated as your medical power of attorney, do they know your feelings on transfusions, or and
Mhm.
any specific strong feelings you may or may not have, right?
Yeah.
um, and then to put something in place for that, to just think about that, and then so talk to your loved ones and put something
Yeah.
in place, I
Yeah,
guess, is
just put
kind of
something in
my.
place
Yeah.
today.
I think
Yeah.
that's good.
Yeah.
That's great.
Good.
Thank you.
Beautiful.
Yeah.
So we've pretty much talked about the package, not saying and that package can be expressed in different ways,
Mhm.
but we've talked about that package. And what I also heard flowing through there was it's just better to do it today. It's better
Mhm.
to do it now as opposed to after death or when something happens to you and you can't make the decisions anymore. And it's also better to do it now than once you find out something like a diagnosis and now you're in a mad scramble.
Yeah.
Just do it now so that you can take the time. I know with us, you guys just took the time. When we did the directive, I was like, yeah, this one is for me, you know? And my
Mhm.
husband was like, oh my gosh. And it took us
it's
like 2 or
it's
3 weeks
interesting.
before
People
we
come
came
in
back.
and they just assume their partner knows what their wishes are, or and they have very it's interesting as the attorney because I'm like, I can walk out if you need like
Yes.
because like
That's my
because they
husband's like,
Some alone
like,
time on
wait,
this one.
yeah, like
yeah.
you think
Yeah.
that? I thought this and like
Yeah.
anyways, it's just communication is a big thing.
I was like, God wants to take me? Let's do it, And my husband was like, and then even for him making his decision, that's where we had to step away for a couple of weeks and then come back, because it was like, but what would people feel if I did this? Hey, what do you want, honey? And it took a minute for him to just come to a decision. And I personally didn't even want to rush him. Just take your time.
But then it takes the scary part out of it. Some people are really hesitant because they're just like, oh, it's about death. I don't want to think about this. All this.
Absolutely.
Yeah.
Yes.
And
Yeah.
Yeah, so doing it now, I think, just gives you time and you don't have to feel rushed, right? But thank you so very much.
yeah, it's my
This has
pleasure.
been
It's
so
really nice
nice.
getting
Enjoyed
to
it.
know.
Thank
I
you.
can't believe the hour's gone.
I know.
Yeah, just like that, just like that.
Yes.
All right. Thank you again for joining us for Her Presence. Make sure that you share, make sure that you like, subscribe, YouTube. We are on Spotify and Apple,
And all those famous places that you find.
all those
podcasts.
famous places.
You said famous.
Yes. See you next time. Thank you.